record. There we go. You're good.
Welcome to the Contra Costa County Bar Association Senior Sections Program, the current status of the rule of law and the impact on it felt by recent developments in our society. This is part of Law Day celebrations, which are suggested by the American Bar Association and held each year on May the 1st to celebrate the rule of law in our society and to cultivate a deeper understanding of the legal profession. My name is Richard Flyer. I'm a retired Superior Court judge from the County of Contra Costa. I'm currently involved in alternative dispute resolution, and I'll be your host for today's program. We were honored today by our special guest, Dean Erwin Chemerinsky, who in all probability needs no little introduction for each of you. You've either been taught by him or you've read him. And our audience today is well into the 3 digits as testimony to his position of respect and admiration in the legal community. And this is a Friday afternoon, after all. The Dean is currently Dean of Berkeley Law. He was the founding Dean of UC Irvine School of Law. He also taught at Duke University, USC, DePaul College of Law, and UCLA. The Dean is in search of a steady job, it looks like. The Dean has written 12 books, has authored more than 250 articles on constitutional law, criminal procedure, and federal jurisdiction. And he writes regularly for the Los Angeles Times, the Sacramento Bee, the ABA Journal, and the Daily Journal. He has appeared in the US Supreme Court, but is known best, I believe, as a court watcher, and is himself watched as the most influential person in legal education in the United States today. In his spare time, and I emphasize that in his spare time, I'm not sure when that happens, Dean, he generously donates his knowledge and wisdom to speak on topics of critical interest to a free society. So Dean, thank you very much for being with us today and sharing your thoughts on our topic of today, which is the rule of law, its status and its future. Just to get the topic going, I'd like to give everyone the definition of the rule of law as promulgated by the ABA. So I think it gives us a groundwork to start with. And that states that the rule of law is a principle under which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. That's the basic definition. And Dean, we're all anxious to hear what your sense is as to how the rule of law is doing. So thank you very much for being here. And I'd like to hear from you now, if you wouldn't mind.
Thank you so much. Thank you for the kind invitation to speak. Thank you for everything in terms of allowing me to be part of this program. I only wish that we'd be together in person. I think that the last 6 months in the United States, we've seen the greatest threat to the rule of law in American history. The guardrails of democracy held, but just barely. That's what I want to talk about today. And I want to address 4 questions. First, what is the rule of law? Second, what was the threat to the rule of law that we've recently seen? Third, what are the underlying issues with regard to the threat to the rule of law? And fourth, what are the solutions? Let me start with first, what is the rule of law? You've just read the ABA definition of the rule of law, and I certainly agree with it. But let me also try to make it more operational in terms of some of what I believe the rule of the law involves. One aspect is that the government operates under the law, that there is no rule of law if the government can disobey the law and do whatever it wants. Second, I think, core to the rule of law is that the government is chosen by a democratic process. There isn't a rule of law if the government comes into power in either way. Third, all individuals and entities have to operate under the law created by the democratic process. And this includes all persons, all corporations, all entities. And fourth, no one, not even the President of the United States, is above the law. To me, if all four of these are met, then we could say that we are a society that operates under the rule of law. If any of these is absent, then the rule of law is missing. Now, I realize I didn't include all which is in the ABA definition. It, for example, refers to international principles of human rights. And then I think we really get to the content, whereas I think the rule of law is much more about process and especially about accountability. Well, it brings me to my second question. What was the threat that we saw to the rule of law? I want very much in my remarks today to be nonpartisan. I would hope that whether you identify as Democrat or Republican, liberal or conservative, you would agree with what I'm describing for you today. And yet I fear when I say the following, it's going to sound partisan. There was an attempt by President Donald Trump and his supporters to undermine the outcome of the election that was held on November 3rd, 2020. Joe Biden won the popular vote by 7 million votes. Joe Biden won the Electoral College in a decisive manner. And yet, Donald Trump and his supporters tried mightily to overturn the results of the popular vote in the Electoral College and for Trump to stay in the White House. This was based on a repeated claim of voter fraud, in a sense that the election was stolen from Donald Trump. Now let me be nonpartisan. 33 court cases were decided, by my count, that involved challenges to the 2016 election. These were challenges brought by Trump directly, or by the Republican Party, or by Trump supporters. In 32 of 33, the Trump position lost in court. In the one instance they prevailed, it was a relatively minor suit about allowing poll watchers to stand closer to observe the counting of absentee ballots. Didn't matter whether the judge was identified as Democrat or Republican, or liberal or conservative. Didn't matter whether the judge was relatively new to the bench or had been there a long time. All of the judges rejected the claim of there having been voter fraud. If there was a single case that I would point to in this regard, it was a decision of the United States Court of Appeals for the Third Circuit involving the counting of votes in Pennsylvania. And Third Circuit Judge Bibas, appointed to the court by President Trump, said there was absolutely no evidence presented of illegalities or of voter fraud. To me, this is what makes it nonpartisan. To have a judge who was self-identified as Republican, known by all for being conservative, and put on the bench by Donald Trump, so forcefully stating that there was not evidence of voter fraud in Pennsylvania. I could point to similar decisions by, again, Democratic and Republican, liberal and conservative judges in states such as Wisconsin, Georgia, Arizona, Nevada. Well, ultimately, this crucial guardrail of democracy, the judiciary, held. The judiciary made sure that the rule of law was followed, that the government operated under the law, that the government was chosen by the democratic process, that all of the officials involved followed the law, and that even Donald Trump had to be covered by the law. But it's so easy to imagine the guardrails of democracy might have failed. What if the election officials in Michigan and Georgia caved to the pressure from the President of the United States and his supporters? What if they had refused to count certain votes so that Trump would have carried Michigan and Georgia? What if state legislatures had caved into this pressure? President Trump reached out to the legislators in Pennsylvania and Michigan and asked them to award him the electoral votes of that state, notwithstanding the popular vote. What if the courts had been partisan rather than nonpartisan? We're so used to, in talking about the Supreme Court, discuss the liberal and conservative justices. And President Trump said, and was quoted often, that he believed that the Supreme Court with 6 Republican appointees would come to his rescue. It didn't, but what it had. What if the Vice President of the United States, Mike Pence, had said on January 6th that he agreed with President Trump that there had been fraud in these states, or that they had changed the rules impermissibly, so he wasn't going to count the electoral votes from these states, or was going to recognize alternative slates of electors, and would have given the election to Trump. Any of those could have easily happened, and then the rule of law would have failed. Then our government wouldn't be operating under law. It wouldn't be chosen by democracy. We'd have a president above the law. Well, this then brings me to the third part of my remarks, and what I would spend the most time on. What is the continuing underlying threat to democracy into the rule of law? What I've said to you today about the guardrails of democracy holding has been uttered by so many people since January 6th and January 20th. And everyone can breathe a sigh of relief that in this instance, the rule of law triumphed. But I am less sanguine. I believe that there are deep flaws embedded in our Constitution that put the rule of law in jeopardy. Let me talk about these threats to democracy and the rule of law. Think about the branches that exist at the federal level. Let me start, since we're focusing on the president initially, with that. The Electoral College. Joe Biden won by 7 million votes. But if 49,921 votes had come out differently in Arizona, Georgia, and Wisconsin, then Donald Trump would have been president. Twice in this century, in 2000 and 2016, we've had presidents chosen even though they lost the popular vote. And it almost happened in 2004. Had John Kerry won Ohio, he would have been elected president despite losing the popular vote. And I say it almost happened in 2020. Today, states with 22% of the population can choose the president. I can go into the reasons as to why I think it is much more likely today and in the 21st century that somebody who loses the popular vote can win in the Electoral College. I mean, after all, in the 20th century, not once in 100 years did the person who lost the popular vote end up winning the Electoral College. We've had it twice since the year 2000 and almost on 2 other occasions. I believe that the Electoral College is inconsistent with a precept of the rule of law because it doesn't have a government that's chosen by a democratic process. It's profoundly anti-democratic to have somebody lose the popular vote, but still end up as the president of the United States. Why do we have the Electoral College? Well, if you go back to the discussions at the Constitutional Convention, it's clear that it was based on a distrust of the people. In fact, in the Federalist Papers, Alexander Hamilton said, we need to have the president chosen by an elite that's sufficiently aware of the issues to be trusted in this regard. They didn't want to leave it to the masses. Also, there's no doubt that the Electoral College was created to protect the institution of slavery. Under the Constitution, if there weren't an Electoral College, the slave states would have had no benefit in choosing president from their slave population. Slaves obviously were not able to vote. One way in which a compromise was reached at the Constitutional Convention was to say that in allocating seats for the House of Representatives among the states, states would get credit for 3/5 of their slave population. It said everyone would count, but slaves or other persons would count as 3/5 of a person. And so in getting seats in the House of Representatives, Southern states, slave states, got the benefit of their slave population. Well, how is it determined how many electors a state gets in the Electoral College? It gets the sum of its representatives and its senators. So it gets a benefit of its slave population in the number of electors it gets in Electoral College. This was not coincidence. At the Constitutional Convention, Hugh Williamson, a delegate from North Carolina, talked about the importance of Electoral College in protecting the political power of slave states. None other than James Madison echoed this at the Constitutional Convention. We should be troubled that this institution, the Electoral College, motivated by a distrust of the people and a desire to protect slave states, still is how we choose the president. If you accept my definition of the rule of law, I'd say it's inconsistent with that. Well, a second institution created by the Constitution is the United States Senate. The Senate, too, is profoundly anti-democratic. The Constitution says that every state, regardless of population, gets 2 senators. This, too, was a part of a compromise baked into the Constitution. There's a debate at the Constitutional Convention about whether to allocate representatives in Congress on the basis of population or on the basis of giving each state equal influence. And so they decided to make House of Representatives, which is allocated by population, and a Senate where it was every state having the same influence. But what's changed since 1787 is the disparity in population between the smallest states and the largest states. In 1787, Virginia was the largest state in the country. Delaware was the smallest in population. The population in Virginia was 12 times larger than that in Delaware. In 2010, after the last census, California was the largest state in population. Wyoming was the smallest state. California has a population 65 times larger than that, Wyoming. And from all we know, that's going to be much larger in a disparity after the counting of the 2020 census. Yet California and Wyoming each get 2 senators. California, therefore, has, in terms of its voters, far less influence in terms of the Senate than Wyoming. And of course, that plays out then in the Electoral College, where Wyoming voters get disproportionately more say in terms of being president than California. Well, let me give you a specific statistic here that to me is stunning. At this moment, we have 50 Democratic senators and 50 Republican senators. But the 50 Democratic senators represent 42 million more people than the 50 Republican senators. The anti-democratic nature of the Senate is increased, exacerbated by the rules with regard to the filibuster. Effectively now, to pass any legislation takes 60 votes in the Senate. How did this come to be? Well, the Senate originally had no rules about limiting debate. And then the Senate adopted rules that allowed for a supermajority to limit the debate. And the practice developed of senators engaging in filibusters. But the filibuster that existed then is that which we all remember from the wonderful Jimmy Stewart movie, Mr. Smith Goes to Washington. A senator would have to hold the floor until he or she literally collapsed from exhaustion or passed the baton on to another senator. The senators had to be present during the filibuster because at any time a cloture vote could be held. Filibusters were relatively rare. They were important, just not common. One area where they were particularly significant was with regard to Southern senators filibustering post-civil rights legislation. In 1975, the Senate changed the rule with regard to filibusters. No longer does a senator have to hold the floor in order to filibuster. The rules were changed so the Senate could continue its business even when there's a filibuster. All the senator has to do is indicate a desire to filibuster, and it would take 60 votes to cut off the filibuster. And the senators will have advance warning of when that's going to be. They don't have to remain in the chamber while somebody's filibustering. The number of filibusters has tremendously, exponentially increased. And so now it would take 60 votes for any legislation to get past that. The Senate, during the Obama presidency, eliminated the filibuster by changing its rules for presidential nominations, federal court of appeals, or district court positions, and for cabinet positions. And so for those, it takes a simple majority. The Senate, during the Trump presidency, changed the rule to say that there can't be filibusters for Supreme Court nominations. So it takes a simple majority. And there is, for budget bills, an unusual process called reconciliation, which can allow a bill to be adopted without the possibility of filibuster. But that's quite limited, and it can't involve the, outside of the budget process, new legislation. The major accomplishment of the Biden presidency legislatively, the massive act that was created, was able to be adopted because it was deemed a reconciliation matter and Republican senators could not filibuster. Not one Republican voted in favor of that bill. Had been subject to filibuster, it wouldn't have been adopted. But the filibuster greatly increases the ability of 40 senators representing a small minority of the population to block legislation. Again, if you'll accept my definition of the rule of law, it's inconsistent with majoritarian democracy. Well, a third branch of government created by the Constitution is the House of Representatives. It was supposed to be the democratically elected branch. Unlike the president and the Senate and the federal courts, this was the one that was supposed to be allocated on the basis of population. But sophisticated partisan gerrymandering keeps the House of Representatives fulfilling that role of being popularly elected. Partisan gerrymandering is nothing new. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize the seats for that party. It's where, say, a Republican-controlled state legislature draws election districts to maximize seats for Republicans, or Democratic-controlled state legislature draws congressional seats to favor Democrats. What's changed is, because of sophisticated computer programs, it is possible to engage in successful partisan gerrymandering more than ever before. Take the example of North Carolina. Republicans gained control of both houses of the North Carolina state legislature. They then engaged in gerrymandering. They explicitly said that their goal was to draw congressional districts so that Republicans would have 10 of the 13 seats in Congress from the state of North Carolina. The report was quite candid. It said it would draw the districts to give Republicans more than 10 of 13 seats if only they could find a way to do so. They ran 3,000 maps of how districts could be drawn in North Carolina. They picked the one of the 3,000 that maximized the chance of Republicans winning 10 of 13 seats. In 2016, and then again in 2018, Republicans and Democrats got almost the same number of votes cast statewide for seats in the House of Representatives in North Carolina. But, as predicted and hoped, Republicans won 10 of 13 seats in Congress. This was challenged in federal court. The case was Rucho versus Common Cause. And in June 2019, the Supreme Court in a 5-4 decision held that challenges to partisan gerrymandering cannot be heard in the federal courts. Chief Justice Roberts wrote the opinion for the court. It was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Justice Ginsburg wrote the dissent, joined by Justice Breyer, Justice Kagan wrote the dissent, joined by Justice Ginsburg, Breyer, and Sotomayor. Chief Justice Roberts said, there's no intelligible standards for determining when partisan gerrymandering has gone too far. So therefore, this should be a matter left to the political branches. In the language of federal courts, challenges to partisan gerrymandering have to be dismissed as non-justiciable political questions. After the 2020 census, there's going to need to be redistricting for seats in the House of Representatives, state legislatures, city councils, county board of supervisors. But in general, the government will be able to engage in partisan gerrymandering with impunity because Rucho versus Common Cause said there can't be challenges in federal court. Now, states can adopt independent districting commissions like California, like Arizona. State Supreme Courts might find partisan gerrymandering violates state constitutions like in Pennsylvania. But short of that, the Supreme Court has said there's no limit on partisan gerrymandering. Justice Kagan wrote a forceful dissent in which she said ties this back to the idea of the rule of law. She said, in democracy, elected officials are to be chosen by their constituents, the voters. She said partisan gerrymandering means that the elected officials are choosing their constituents, the voters. So this isn't something to leave to the political process, that legislators who benefit from partisan gerrymandering are not going to oppose it and favor something that would put them out of office. So here too, when you look at a branch of the federal government, you see a real threat to democracy. Well, this leaves the federal courts, the Supreme Court, federal courts of appeals, and district courts. This was intentionally meant to be an anti-democratic branch of government. The president appoints these judges and justices, the Senate confirms. And once confirmed, these individuals have life tenure. And this was to protect judicial independence, the goal of making sure that judges decide cases on the basis of their best view of the law and facts, not to please constituents at the next election. And yet, when you look at what's happened, you see how much the courts have furthered the anti-democratic nature of American government. Some statistics. Since 1960, we have had 32 years with Republican presidents and 28 years with Democratic presidents. In 2024, we'll have had 32 years with Republicans and 32 years with Democrats, which is really astounding. But during this time, Republican presidents have picked 15 Supreme Court justices, and Democratic presidents have picked 8 Supreme Court justices. This is largely about the accident of history for when vacancies have occurred, but the Republicans blocking Merrick Garland and rushing Amy Coney Barrett certainly contributed to this. Now, to combine this with what I said earlier, Brett Kavanaugh was picked by a president who lost the popular vote and then confirmed by senators who represented 44% of the United States population. And now he's going to be on the Supreme Court for life. This is not a short-term phenomenon. Amy Coney Barrett was 48 years old when she was confirmed for the Supreme Court. If she remains until she's 87, the age which Justice Ginsburg died, Barrett will be a Supreme Court justice until the year 2059. Neil Gorsuch is 53, Brett Kavanaugh is 55, John Roberts is 66, Sam Alito just turned 71, Clarence Thomas is going to turn 73 this year. I've long thought the best predictor of a long lifespan has been confirmed for a seat on the United States Supreme Court. Easy to imagine these justices being together for another decade or two. And so I worry very much about American democracy. When all of the institutions of democracy are so profoundly anti-democratic, can we really have a government under the rule of law? Well, this leads me to the fourth and final part of my remarks. What are the solutions to this? Again, let me give you some thoughts institution by institution. In terms of the presidency, I would like to see us eliminate the Electoral College. But this would take a constitutional amendment. The Electoral College is provided for in the Constitution. Constitutional amendment takes 2/3 of both houses of Congress and 3/4 of the states. The smaller states that benefit from the Electoral College are not about to change this provision and are not about to eliminate the Electoral College. There is a proposal for a national popular vote compact where states would promise that they would give their electors to whoever won the popular vote. To this point, only so-called blue states have ratified it. Unless significant red states ratify it, it won't go into effect. But I also worry that it can't solve the problem. It's not enforceable. What if Texas had joined the popular vote compact and said that it would give its votes to whoever won the popular vote in the Electoral College? And in the election, it turns out that Trump lost the popular vote, but if only Texas would give Trump the electoral votes, he would be president. And imagine that Trump carried Texas. Texas would say, it's nice we signed on to that compact, but we're not going to follow it now. How could it ever be enforced? The one remedy that I think of that would help with regard to the Electoral College is eliminating winner take all. Except in Maine and Nebraska, whoever wins the popular vote in the state gets all the electoral votes from that state. And I've seen statistical analysis that without winner take all, be much less likely that somebody could win the popular vote and lose the presidential election. But here, there's what my colleagues call a collective action problem. No state wants to practice unilateral disarmament. California doesn't want to eliminate winner take all until it knows that Texas is doing the same thing. And Texas wouldn't do it unless it knew California was going to do the same thing. And so I don't see a way of the states doing this on their own. I think conceivably Congress could take action to eliminate winner take all, consistent with the Constitution, and perhaps something Congress will consider in the future. In terms of the Senate, it is not possible to change, even by constitutional amendment, the number of senators that each state gets. Article 5 of the Constitution, which concerns the amendment process, outlines only a few things that can't be changed by amendment. And one of those is how each state gets equal representation in the Senate. Now, increasing the number of states would be a way of making the Senate more representative, make DC and Puerto Rico into states, but that would be subject to filibuster, and it's not likely that that would be able to get through the Senate. It would take legislation. I would like to see the Senate eliminate the filibuster. I think the filibuster is profoundly anti-democratic and unconstitutional. The Constitution in Article 1, Section 7 specifies the way laws get adopted, and it's clear it's meant to be by majority vote. The filibuster requires a supermajority. At the very least, I would like to see a return to the old filibuster, the talking filibuster, where somebody would have to hold the floor of the Senate and keep it or pass it on, and all the senators have to be there for cloture votes to dramatically reduce the likelihood of filibusters. In terms of the House of Representatives, I would hope that states would adopt, as California has, independent districting commissions. There's nothing to keep states from doing that, but only a minority of states have such independent commissions. I would hope in other states that state courts under state constitutions would find that partisan gerrymandering violates their law. In terms of the Supreme Court, I would like to see term limits. I would favor 18-year non-renewable term limits. I think it's a way of making the Supreme Court more democratic, more of a check. The number of the 18-year non-renewable terms, I fear, would take a constitutional amendment because the Constitution gives to Supreme Court justices their positions for life. But some of this is just about lifespan and life expectancy. When the Constitution was written, average life expectancy was 36 years. Now it's more than double that. And again, I think too much depends on the accident of history when vacancies occur. Clarence Thomas was confirmed for the Supreme Court when he was 43 years old in 1991. If he remains on the bench until he's 90, the age which Justice Stevens retired, he'll be a justice for 47 years. So this doesn't sound partisan. Elena Kagan was 50 when she went on the Supreme Court. If she remains until she's 90, that's 40 years. That's too much power in a single person's hands for too long a period of time. I would favor increasing the size of the Supreme Court to restore ideological balance. Remember, since 1960, Republican president appointed 15 justices and Democrats only 8. That too would require legislation, and the filibuster would block it. And there's no indication that there's a majority of the Senate that would be willing to change the filibuster rules. So I have focused on the rule of law in terms of democracy because it relates to every other aspect of the rule of law. What I've tried to suggest to you today is how the Constitution is deeply flawed and how changes in recent years have increased those problems. Maybe it's time to start thinking about a new Constitution. If we can't amend the existing one, if we can't eliminate electoral college or equalize representation in the Senate based on population, or eliminate partisan gerrymandering, or create term limits for Supreme Court justices in separate amendments, maybe we should overall think of a new Constitution, and a Constitution that's even clearer in making the precepts of the rule of law in its text. The rule of law is so fundamental to what we should be, most aspire to be as a society. You know, what I've tried to suggest to you is there are threats to the rule of law. They manifest themselves in the 2020 election, but I worry even more for the future. Thank you.
Thank you so much, Dean Chemerinsky. I think, oh, here we go. Here's Judge Flyer.
Fascinating talk, Dean. I guess one of the things I want to divert just a little bit, but direct your attention to something that I wasn't aware of until I attended another session, that the topic of civics, which is something that each of us, at least my age, got a dose of in high school and even grammar school leading up to it, is no longer taught in California schools. And I don't know if that's the situation throughout the nation, but part of the concern I have with your description of the rule of law and how important it is whether or not the mass population even understands it or recognizes it. Certainly it's talked about at every political convention, but whether or not they understand basically what the rule of law means.
I think our country does a poor job at civics education. I think the survival of democracy and the rule of law will depend upon civics education. I was discouraged when I saw a poll that more people could name some of the 7 dwarfs than could name justices on the United States Supreme Court. I was discouraged that when a newly elected senator from Alabama was asked, he couldn't name the 3 branches of the federal government. This is a man who's now in the United States Senate. How could that be that any citizen of the United States would not know the 3 branches of the federal government? Judge, I think we have a special role to play as lawyers and as judges and as law professors and as law schools of going out into the community and doing civic education. I think we need to go to junior high schools and Rotary clubs and Lions clubs and every other group that we can think of and explain to them just the basics with regard to civics. When I was at Irvine, which you kindly mentioned, I went to every 8th grade class at the public schools in Irvine, I think at some of the private schools too, and talked to the students who were studying the Constitution just about basic civics and about some of the rights that were of special interest to them as students. We need to all be doing much more of this. And yes, we should be making it part of our curriculum. Something else that I've noticed, and people who know me are probably tired of my hearing about me, but this way, but just about every dramatization I've seen of police work and police conduct that's on TV, the Law and Orders and the this, that, and the other, they portray the police officers as people who sort of wink the other way when it comes to specific policies of search and seizure, and it seems like they have a policy of the ends justifying the means, which is the exact opposite, I'm afraid, of what
what a free society should be all about with its rules and its policies. Is this something also that goes along with the rule of law and the lack of awareness of the rule of law?
We depend on the police to enforce the law. They're integral, therefore, to the rule of law. And it's essential that the police perform their jobs under the law and not take the law into their own hands. I think you're absolutely right that policing shows often misrepresent the police. 20 years ago, it was actually in 2000, I did a report on the Los Angeles Police Department after the Rampart scandal. I interviewed about 100 police officers for it. I was tremendously impressed. The police officers talked about the proudest day of their life was getting their badge. And I believe that overall that the police are very conscientious, that overall they try very hard to exercise the discretion in a proper way. That said, we know that there's a problem of racism in policing in the United States. Some of it is implicit bias, that we all have our own biases, and it often manifests itself in terms of race. Some of it is recently documented in a study by the Brennan Center. The number of police officers who are part of white supremacist groups is quite frightening. And so I think we need both to applaud the police for what a hard job they do under the most difficult circumstances, but also look to improve policing and to make it far less racist than it's been through American history.
The other thing that I thought was important in the analysis that you gave was just the information that we can accept as truthful information by our news sources. You know, I grew up with Walter Cronkite and Huntley and Brinkley, and you could sort of trust that news source. One of the things that seemed to be happening in our elections and even after is our public no longer relies upon what I would call dedicated news agencies. They rely upon the internet, and the internet is not always the best source of information to make important decisions.
This is such an important topic. It's crucial to the rule of law and democracy, as well as just so much else. And maybe you'll be kind enough to invite me to come back and talk about the internet and its relation to democracy. On the one hand, the internet is the most important tool for communication since the development of the printing press. It's democratized the ability to reach a mass audience. It used to be to reach a large number of people, you had to be wealthy enough to own a newspaper or get a broadcast license. Now, anyone with a smartphone or a modem, just access to a modem, can reach a mass audience. The internet gives us access to infinite information. I'm sure we've all been part of dinner table conversations where we resolve them by just going on, looking up the fact. But the internet has also had very destructive effects. It can spread false information and do so very quickly. That can defame people and injure their reputations. It can invade privacy. Also, instead of us all having the source like Walter Cronkite or Huntley and Brinkley, people now can go to the source of information that they most agree with. And if you're liberal, you have your sources. If you're conservative, you have your sources and the like. And the development of the internet has really caused many newspapers to go out of business. The statistics about newspapers going out of business in news deserts is really frightening because major newspapers haven't found a way to monetize they're being accessible over the internet. So there's a huge problem in terms of the internet relative to democracy and therefore relative to the rule of law. There's no easy solutions, but invite me back and we'll talk about that.
Okay, and you know, you had mentioned the guardrails that I think all of us looked with horror as we saw the capital of our nation seemingly invaded by, I can't say an unruly mob, but certainly Americans who had a different view of how democracy was going to be dispensed. And it seems like the rule of law, you know, came to our defense in a lot of ways and saved us. But part of the concern I had just dealt with the congressman, not being partisan once again, but more to the sense of, it seemed like in the various impeachment votes and the various other votes, that were occurring at the time, whether or not people were relying upon the same information and facts that many of us saw. And that's part of a democracy, but my goodness, it seemed like partisanship had taken the place of the importance of the country.
This is a great place to end our conversation. What occurred on January 6th is the antithesis of the rule of law. An angry mob storming the Capitol in a way that's never before occurred in American history. And what was so frightening is this wasn't something we were watching in a foreign country on the news. This is something that occurred in Washington, D.C. And their goal apparently was, among other things, to execute the Vice President of the United States. Their goal was to try to overturn the results of an election. We would never think it could happen here, but it did. Now, thankfully, the Senate and the House didn't cave into the pressure, but there were senators and representatives who would have done so.
Mhm.
Thank you so much for having me. And again, I'd love to come back.
Okay, well, thank you. You will certainly be on our A list. I'm not sure where you get the time to do all this work, but on behalf of the senior section and the Bar Association in Contra Costa County, we sincerely appreciate your taking the time to be with us and talk about this thing that is the very basis of our legal community and in our country itself. So thank you once
My
again.
great pleasure.
Okay.
Thank you.
Bye-bye now.
Thank you.